Hello, everyone, and thanks for joining us today. I'm Mallory Hendry, Content Specialist Manager with Canadian Lawyer, and I'm pleased to introduce today's webinar, 2024 Decisions That Have Changed the Canadian Estate Litigation Landscape. Today, we're joined by Kimberly Whaley, founding and managing partner at Whaley Estate Litigation Partners, and another partner from her firm, Bryan Gilmartin. As well, we have Ian Hull, co-founding partner at Hull & Hull, and the managing partner at his firm, Suzana Popovic-Montag. This panel of renowned estate litigators will discuss the critical court decisions that are driving the shifts in this area and share related insights and strategies to help you enhance your practice. At the end of the presentation, there will be a question and answer period if time allows, so type any questions you have into the Q&A box. I'll turn things over to our panelists now to begin the presentation. Take it away, Kim.
Good afternoon, everyone, and welcome. Today, our panel are going to address some 2024 decisions with the goal of providing 8 takeaway practice tips from these decisions. We've had a lot of decisions this year, giving litigators, I think, pause when advising their clients, and certainly a great number of appeal court decisions. So let's get started with one of my favorite of the year, the decision in William Robert Waters and Gillian Henry. This one, the court dealt with a host of legal issues and claims. It was a very lengthy decision. And the court, in essence, had to determine whether an elderly man intended to gift $30 million in assets and real property to his wife's caregiver. He had struck up a romantic relationship with her. And then the other question the court had to look at was whether the caretaker or caregiver was required to return any of his estate upon his death. So briefly turning to the facts. In the 1990s, Phyllis was involved in a catastrophic accident which left her housebound and a recluse. Both William and Phyllis were seeking nighttime PSW assistance and hired Gillian Henry to assist Phyllis. By the point in time in their marriage, they were living on separate floors and their marriage relationship was strained. Soon after Gillian started working with them, the relationship as between William and Gillian started, and it lasted for a duration of in or about 10 years up until William's death. Within a few months of starting, $100,000 was transferred to Gillian for her to buy a Mercedes SUV. And this, in effect, started the succession of transfers that would transpire over the next 10 years. The transfers included property, money, real property, jewelry, clothing, etc. But towards the end of William's life, he began to run out of money. So he then started taking from his wife Phyllis's assets and her bank account to the tune of in or about $5.4 million, which was traceable. William controlled Phyllis's assets through a power of attorney for property, and at death, Phyllis was left with only $500,000 in assets, and that wasn't sufficient to fund her ongoing care needs. So what did William's co-estate trustees do? They commenced an action against Gillian, and this is how it ended, more or less. Notwithstanding the innumerate claims, and I'll leave that to you to review, the court found that the majority of the transfers that William made to Gillian were indeed gifts. Gillian was, however, ordered to return $2.85 million improperly gifted from the funds of Phyllis, and the estate of William was entitled to an 80% interest in an investment property under the doctrine of resulting trust. On addressing whether the transfers to Gillian were gifts or whether William intended the money would return on his death, the court relied on the test established to gift in McNamee and McNamee. It was a 2011 Ontario Court of Appeal decision, where the court said one has to show the donor intended to donate the gift, there was sufficient delivery of the gift, and there was acceptance of the gifts. William's estate attempted to use various remedies to prove that William did not intend to give the transfers. Most of them failed. And all of the ones that you see on the screen there were canvassed in detail by the court. Gillian was successfully able to demonstrate William's intention to gift, and in part, this was because of the evidence given that William knew that Gillian was spending the money on cars and jewelry and vacations. He reviewed all of his visa statements before authorizing the payments. The checks were issued to Jillian and signed by William, and the transactions were all personally approved by William himself. One of the two successful remedies claimed by William's estate was the one property that was returned by way of resulting trust. And that was a ranch property that Jillian had built a horse stable on. It was called the King of Hearts. William's estate, though, was able to provide evidence that William had always treated this as an investment property, and that he had often commented to his advisors that he wanted to get his money out of this investment because it wasn't a sage investment. Jillian wasn't able to rebut the presumption of resulting trust. So because there was a fiduciary relationship found not only between William and Phyllis, but also between Phyllis and Jillian, the court looked at the fiduciary obligations and the scope and said these are the characteristics that demonstrate a fiduciary obligation, that the fiduciary has the scope for the exercise of some discretion or power. That power can be unilaterally exercised, and the beneficiary is particularly vulnerable or at the mercy of the fiduciary holding the discretion or the power. So in the end, Jillian was not entitled to keep Phyllis's money. And Justice Callahan importantly held that William and Jillian's actions were unconscionable, and that the doctrine of equitable fraud precluded Jillian from retaining the monies. She was reordered to pay them to the estate. And I just want to comment in conclusion on this case, that these types of situations involving an estate often have evidentiary hurdles. And notwithstanding that, we see a rise in equitable remedies being successfully applied, and now a common theme. In this instance, resulting trust in unjust enrichment and unconscionability, as well as the doctrine of equitable fraud, were all tools that the court was able to apply to resolve the fiduciary breaches as between the group of them. With that said, over to Suzana for our next case.
Thank you very much, Kim. And just before I get into the next case, I wanted to mention to our participants that our slides and any cases that are mentioned in addition to the slide deck will be available after this presentation. So the next notable case that I wanted to discuss was the 2024 Ontario Court of Appeal decision of Anatowich Estate versus Anatowich. In this decision, the main issue concerned whether perhaps there was more than one legal test for the rectification of a will. In terms of background, the deceased died in 2020, leaving 2 children, Markian and Yolana, and 3 grandchildren who were Yolana's children. The deceased had executed a last will and testament many years earlier in 2009, and his will provided that 10% of the residue of his estate was distributable to his grandchildren, and the balance of the residue of the estate was to be distributable to the deceased issue, being his biological children, alive at the date of death. Now, the deceased estranged son, his biological son, Alexander, and his 2 minor children filed a notice of objection to Yolana's probate proceeding when they caught wind of the terms of the will and of Yolana's intention to exclude them as beneficiaries of the estate. Alexander claimed that he had a residuary interest in the estate because he fell within the definition of the deceased issue, that is, his biological children, and that his children were also entitled to an interest in the estate since they were the deceased grandchildren. In response, Yolana brought an application to rectify her father's will to specifically exclude Alexander and his children from it. And the application judge ultimately granted Yolana's request. Now, at first glance, this might come as somewhat of a surprise to you, as it certainly did to me. After all, as a biological child, Alexander was clearly issue, and his children were clearly grandchildren of the deceased. There didn't seem to be any ambiguity, at least not in my mind, that Alexander and his children ought to have been included as beneficiaries of the estate purely by virtue of the terms of the will. But in considering the request to rectify the will in the circumstances, the court turned to the leading decision of re-estate of Blanca Esther Robinson, which we commonly refer to as the Robinson decision. And the court noted that a court will only rectify a will where there's no ambiguity on the face of the will, as there was none here, And the testator reviewed and approved the wording, as the evidence showed that he had, if one of the following three grounds are present. Where there's an accidental slip or omission because of a typographical error or clerical error, where the testator's instructions have been misunderstood, or where the testator's instructions have simply not been carried out. Here, Yulana framed her request for rectification of her father's will in the following manner. First, she sought to rectify the will to limit the 10% interest of the grandchildren to her and Markian's children, to the exclusion of Alexander's children. And second, she sought to limit the remaining 90% of the inheritance to herself and her brother Markian, so as to completely exclude Alexander. In other words, she was looking to exclude Alexander and his children, who otherwise would have fallen within the traditional class of issue and grandchildren as intended beneficiaries of the estate. So why did the court agree to rectify the deceased's will? Well, in applying the test in Robinson, it noted that, firstly, the drafting solicitor admitted that because he had used a standard form will precedent, he didn't actually accurately capture the deceased's intentions or his instructions in the will. The solicitor's notes also demonstrated evidence of the deceased's intention to specifically only include his two children and their children as beneficiaries of the estate, and not Alexander and his. And finally, the court was of the view that the proposed rectification would ultimately carry out the deceased's intentions as set out in the evidence before it. So in light of this evidence, the court held that the test in Robinson was met and the will should be rectified as requested by Yulana. Now, not surprisingly, Alexander appealed on the basis that the court actually applied the incorrect test for the rectification of the will. Alexander argued that rather than the test set out in Robinson, the court ought to have applied the test set out in the more recent Supreme Court of Canada decision of the Canada Attorney General versus Fairmont Hotels, Inc., which allegedly set out a new and different test for the rectification of a will. The Court of Appeal disagreed and ultimately dismissed Alexander's appeal, holding that the application judge had actually correctly invoked the third factor in Robinson to enable rectification, the fact that the deceased's instructions had not been carried out in his will. The court held that the Fairmont decision didn't actually create a new and different test for rectification, as the decision in Fairmont actually followed the test set out in Robinson. And finally, the evidence that was accepted by the application judge was sufficient to allow for rectification of the will. And so his conclusions, which were rooted in the evidence, were entitled to appellate deference, and the appeal was ultimately dismissed with costs awarded to Yulana. Over to you, Ian.
Thanks, Suzana. Well, staying with the theme of seeing what the Court of Appeal is doing, we've had the benefit of the Ingram decision on limitation periods. And this decision, of course, is important on a bunch of levels, but it's the first practice tool that two things I always do when I get a new matter and intake is give me a copy of the will and what is the date of death. Well, this decision really turned on the date of death. It really mattered. And that is, when do you start calculating limitation periods? The deceased died in 2017. He left a will back in the late 80s. But at first instance, the applicant was Ms. Ingram, stated that she was the deceased common law spouse for over 15 years and was left out of the will. And so she also went on the facts were that she had lived at the deceased had lived at her house for years, and that he used his house as a rental home and was therefore allowed to generate some income for the benefit in that regard. So it was important that she actually never factually lived in the deceased house, but so she brought a claim against the deceased estate by way of constructive trust or resulting trust for a share of the estate, and relied on the limitation periods under Section 4 of the Real Property Limitations Act, which gives you 10 years to make such a claim. Well, at appeal, our firm was privileged enough to be able to argue as interveners in this case, so we were directly involved in the decision. And the deceased appealed the decision, the estate trustee appealed the decision of the motions judge. Interesting, again, as the litigator, the motions judge was elevated to the Court of Appeal soon after that judge had rendered their decision. So it's you can never get away from your decision, so to speak. So the question was this: what limitation period applies? The Trustee Act or the Real Property Limitations Act? She commenced her claim outside of the 2-year limitation period from the date of death under the Trustee Act. So she was proceeding on the basis of being covered. Her coverage was through the Real Property Limitations Act because it was dealing with real property. The difference between these instruments is, I mean, these provisions is very important. And Justice Roberts was phenomenal in terms of her analysis. The careful consideration into this decision is a real tribute to, it's fun to read. Sometimes these cases put you to sleep pretty quickly, but this is fun to read. It was clear, plain English, and her analysis was really dead on in terms of at least understanding it. Whether it's right or wrong is for another day. But at the end of the day, she looked at it and said, look, we have to apply some sort of statutory interpretation here. What to determine what is it 2 or is it 10 years? What provisions apply here to protect or not protect this claim? And they dealt with, they looked at the Izendorkov factors that they consider in judicial determination of statutory provisions. And she went on to, again, this is a bit of a law school analysis, so it doesn't really matter to me all that much because it was very helpful if you want to look at interpreting statutes. But the key is that she looked at these 4 factors. The result is really interesting to me because the court came up with a decision that basically said the legislative intent behind the Trustee Act was to go for the shorter period. And one of the key submissions to the Court of Appeal was, do we want a state sitting out there for 10 years in limbo if they are dealing with real estate, right? If you've got real estate assets. So we got some real comfort. The court said, go to the shortest, and came up with a really cool statutory analysis process and told us a good reason why. So thank you, Justice Roberts. The last thing I want to say, though, on this case, though, is that literally weeks after this decision, again, it's got to be tough in the Court of Appeal in terms of any judges finding out what's going on down the hall. There was a decision called Gomez, and I put it in the Slack channel. I'll put the link to the Slack channel, Gomez versus De Silva. And we'll when we circulate to everyone these slides, and we'll make a note of this decision as well. But because quickly that decision came out literally just soon after, and very similar facts where there was a fight, there was an issue between one child was argued constructive trust against a real estate property, and wanted to rely on the Real Property Limitations Act. They tried to actually use the provisions of the Petition and Sale Act to get around some limitation periods. Basically, two of the kids got the real property, and the kid that got cut out said, no, I've got an access. I want to get access to that property via constructive trust claim. I have to, and I'm outside the 2-year limitation period, so I want to go under the Real Property Limitations Act. The court never addressed the role of the Trustee Act in this case. So the same court, within weeks of each other, dealing with a very similar facts, didn't deal with the question, because in this case, the claim was outside the 10-year limitation period. So they didn't even have to go into which limitation period applies here, because they didn't actually get the question of whether the Trustee Act applies or not wasn't even raised. And so, the court got off this because they said, well, you're even outside the 10 years. The important thing to me is this, like there is some watering down of the Ingram decision potentially from this decision. So again, I think the court closed the door on Ingram with 2 years as the lead. Go from day to death, but we have to watch very carefully. So those are my thoughts on that case.
Thanks,
Bryan?
Ian. So we're going to stay in the Court of Appeal, and let's talk about Shannon and Habrowski. And in that case, the court provided guidance as to how the discoverability principle in the Limitations Act applies to will challenges, and whether a limitation period in that circumstance runs from the date of death of the testator. So the facts of that case, the testator had 2 children, Glenn and Gail, and the testator had executed a will in 2006 in which it benefited both children. The testator then executed a will in 2007, which disinherited Gail entirely and removed her as an executor. Now, Gail did not receive a copy of this 2007 will until January of 2015, which was in or about a year after the testator had died, despite making repeated requests for it. Gail did eventually bring an application challenging the validity of the 2007 will in December of 2016, which was more than 2 years following the testator's death. And Glenn opposed that will challenge and asserted that the application was statute barred due to Section 4 of the Limitations Act. Now, Section 4 of the Limitations Act provides for the basic limitation period of 2 years since the claim was discovered. Section 5 of the Limitations Act provides for the discoverability principle of 2 years as of the date that the claim was discovered, such as when the loss or injury occurred, or the day that a reasonable person with the abilities and in the circumstances of the person with the claim first ought to have known. Both of these sections and their application were at the heart of the issue in this decision. And so despite Gail's suspicion that the 2007 will had been executed, she was unable to confirm its existence nor learn of its contents. And on this basis, the court found that the limitation period did not begin to run from the testator's death. And for this reason, Gail successfully rebutted the presumption of Section 5 sub 2 of the Limitations Act, saying that a person with a claim shall be presumed to have known of the matter referred to in Section 5 sub 1 sub A on the earliest day which the claim occurred. Now, Gail provided the court with sufficient evidence that she did not discover the claim in the application until January of 2015, which was when she was able to obtain a copy of that 2007 will. And it was from that moment that the 2-year limitation period began to run. So Glenn appealed, and on appeal, he argued that the Superior Court should have found that Gail's application was statute barred by Section 4, and again argued that because it fell outside of the 2 years from the date of death, it should fail. Glenn at that time attempted to introduce fresh evidence consisting of a letter from the appellant's counsel to Gail, asserting that the testator had executed the 2007 will. And so this was really an attempt to show that the discoverability principle ought not to have applied, and Gail was aware of the existence of the 2007 will prior to January of 2015. Now, the Court of Appeal in its analysis held that the letter did not have an impact on the running of the limitation period imposed by the application judge. The court concluded this on the basis that a mere suspicion of the will's execution was not sufficient information to commence a will challenge, given the importance placed on the contents of the will and the bequest. And ultimately, the court ruled that the application judge did not make any reversible errors regarding the limitation period issue. And with that, I'll throw it back to Kim.
So we're going to move cross-country a little bit now to British Columbia and the Court of Appeal decision there in Barbieri and White. The court was asked to address the scope of solicitor-client privilege as between an executor and a beneficiary, and whether that privilege could be waived. So facts briefly, Lily, the deceased, died in 2018. Her will appointed her daughter Teresa and her son Rick to be her estate trustees and act jointly. At some point, Rick and Teresa could no longer get along or work together, so Rick filed a notice of application to remove Teresa. In the end, as reflected in a consent order, Teresa agreed to her removal as a state trustee, but as a condition to that, Rick would have to provide a bi-monthly accounting of the estate. Soon after that happened, Rick asserted that he and his counsel had inadvertently disclosed privileged documents for an accounting period that ran a period of 2 years from 2019 to 2022. And the court found that Rick had indeed waived his solicitor-client privilege over all the claimed privileged documents simply by the agreement and reflection in signing the consent order. But the court did find also that there was no waiver of privilege on the legal advice given to Rick and to in his capacity as a state trustee, and the legal advice included in the legal invoices. So in looking at the criteria for a waiver of privilege, it may be established where it is shown that the possessor of the privilege knew of the existence of the privilege and voluntarily evinced an intention to waive that privilege. And if that privilege communication or communications were disclosed, the following considerations are then applied to determine if the disclosure was inadvertent or not. So they include whether the disclosure was in fact inadvertent as opposed to repeated or careless or reckless, whether an immediate attempt was made to retrieve the documents and remedy the situation, and whether preservation of the privilege in all of the circumstances would cause unfairness to the receiving party. There was an appeal. The main issue, again, similar. And the Court of Appeal found that Rick had waived his solicitor-client privilege by agreeing to the consent order, particularly because the court classified the disclosure as careless and reckless, meaning it was not considered inadvertent. In the court's words, Rick was attempting to use the privilege as a sword by agreeing to do this disclosure pursuant to the consent order in order to become the sole executor, and then also as a shield to shelter behind the solicitor-client privilege. Again, the Court of Appeal agreed that the solicitor-client privilege regarding the legal advice was not waived. So very interesting decision and helpful. And now we're back to Suzana.
Thanks, Kim. Now, in the 2024 Saskatchewan decision of Levesque versus Clarenbach, the Court of King's Bench addressed disclosure requests of an attorney for property and discussed the limits that may be imposed on these kinds of applications to compel disclosure. Here, the applicant sought an accounting from the respondent, who is her sister, in the prescribed form under the Powers of Attorney Act in Saskatchewan, and also sought a significant amount of additional disclosure. And for this request, she relied on the inherent jurisdiction of the court as authority. Now, the court found that the respondent had already provided the required statutory accounting to her sister, even before the proceeding was commenced. And although there was some dispute about the appropriate starting date for the accounting, the court ultimately held that what was provided was sufficient to meet the statutory requirements. In terms of the applicant's request for additional information and documentation, in the court's view, that was quite extensive. And so in refusing the request, the court held that the applicant could not simply rely on the inherent jurisdiction of the court for such a broad disclosure request. Now, in coming to this conclusion, the court had to determine whether the respondent was required to make the broad disclosure requested by the applicant in light of all the relevant circumstances. And those relevant circumstances included the fact that the respondent had previously disclosed ample documentation for her accounts, that the applicant was unable to point to any evidence of malfeasance or misappropriation of funds, and the fact that the applicant solely relied on the inherent jurisdiction of the court as authority for her request. Ultimately, the court declined to order the additional information because there was an insufficient basis, it said, to justify the additional disclosure, which was, according to the court, over and above what was required by the statute. In terms of the applicant's reliance on the inherent jurisdiction of the court to further order disclosure, the court noted that counsel too often rely on this concept of inherent jurisdiction to support arguments that they can't otherwise articulate. According to the King's Bench, the inherent jurisdiction of the court is not a panacea, and counsel cannot rely on it to request just any remedy not specifically set out in statute. It relates primarily, said the court, to procedural matters and can be relied upon when it's required to administer justice. Furthermore, said the court, it should be used very sparingly. In the court's analysis, having reviewed the accounting that was provided, the applicant had not pointed to any evidence of malfeasance or misappropriation of funds. And as a result, her request appeared to be nothing more than a mere fishing expedition based on vague assertions and many assumptions, said the court. Now, according to the court, the applicant seemed to have brought the application as a result of her belief that her father had far more assets and funds than what appeared in the accounts, likely coupled with a difficult relationship with her sister. Like, we've never heard that before. But the evidence before the court simply didn't support that belief. And as a result, the court concluded that the disclosure requested by the applicant was far-reaching and unreasonable in the circumstances. And really, this serves as a good reminder to us that sometimes good enough really is good enough.
Thanks, Suzana. I'll turn to the Drennan decision. It's Justice Meyer's case in Ontario, and I think it's a good one just to give context to an important aspect of the practice, and that is On the solicitor side, warning clients about costs, and on the litigation side, consequences. So in Drennan, the court was faced with an application. The daughter brought an application to remove her brother as the executor, as trustee. So that's a removal application. There was allegations of conflict between the siblings, unequal bequests. Some of the motivation behind it isn't as important as what happened during the process. So during the hearing of the motion seeking the removal of the estate trustee, the respondent state trustee was self-represented and failed to file his materials. Now I just pause there. In Ontario, we have Rule 15 that should be more enforced, in my view, by the courts a little more vigorously, that requires fiduciaries to be represented. So notwithstanding that, this fiduciary kept going with litigation on an unrepresented basis. So we've got managing costs in estates, we've got unrepresented litigants and unrepresented fiduciaries. Not an impossible scenario to see in our courts, unfortunately, but we have some room to move in terms of protecting it. But throughout the proceedings, the state trustee, they responded, ignored court orders, caused delays. The applicant, the sister, was forced to take loans in order to proceed with the litigation, and there was evidence that the lack of administration was causing her financial stress. In that way, the loans were used solely to fund the application. So it was attachable really typically to the litigation itself, but also to the behavior. And the court awarded interest on the applicant's loans as a disbursement, which was interesting, and looked at some of the basis upon which they should award it. So the court was asked, is this a substantial indemnity award that should be provided here, given the respondent's actions and alleging it as being an abusive process? All of these kinds of difficult pieces of litigation we see, not all, but lots of times in our practice. And so it wasn't an unfamiliar set of facts that was going on here. And the court ordered costs relating to, in part of the fight on a substantial indemnity basis. But the court was specifically looking on the question of how do we deal with the loan interest? So the sister had to go borrow money through a litigation lender, I presume, and had interest on the loan. And the court stated that proceedings found that the proceedings were truly an abuse of process. So you have to have the necessary facts to ring that bell, and also labeled it sort of a scorched earth litigation. And I sort of chuckle because I can't imagine many cases that the four of us litigate. You feel like you're in scorched earth, and how do you ever ring that bell is always a difficult barrier to finding. But in this case, Justice Myers went right at him and said the thing that the respondents can't legitimately do is ignore steps. They can't require other people to bear costs as a consequence of ignoring those steps, behavior that we see all the time. And so it was nice to see a little sanction against the respondent and ignoring court warnings. Basically, the court found this person was a bad actor. So the decision just helps us give us some parameters as to whether we can go to the court and say, this is a really bad one. And this is one that requires a significant cost order against the bad actor. My last point on this is that it's helpful. It's always guided by the facts. And it worries me because when you read this decision, so many of our cases are hitting maybe not that bell, and we didn't have all, but we hover just around that level of, boy, this seems like a complete waste. And non-responsiveness is feeding the fire of wasteful litigation costs by counsel and or unrepresented. So I say, nice to see a judge step into it, but it's very hard to get their attention at this level. But if you're looking for that kind of level, this case will give you some benchmarks and some parameters. And although Justice Myers talked about scurrilous allegations and delay, again, it's hard for me to find a file in my drawer that doesn't have a little bit of that. So it's just a question of how high up the bar is going to be. So anyway, Bryan, let's turn now over to you.
Thanks, Ian. So look, a lot of interesting stuff coming out of these cases this year. There's been a lot of, nuanced issues and I think there's a lot to take away from them. So let's talk about some of those takeaways, the lessons that we can extract from the decisions that can ultimately assist us litigators in our practice. And so if we turn back to the first case, and that was the estate of William Robert Waters and Gillian Henry, really interesting case. I think the first takeaway from that decision is the reminder of the importance of proper planning and documenting of a transferor's intention at first instance. This decision didn't necessarily change the law, but it serves as a caution. If the intention of the testator is not made clear, then the transferee, the person receiving the transfer from the deceased, it could be held to the burdensome task of rebutting the presumption of resulting trust by demonstrating that the transferor intended to make that gift. And so if the file's not properly papered and the evidence isn't there, that is a tall order and a tall task to be taken to.
And by all accounts, in this case, on the face of it, for those estate trustees, it looked as if this was a vulnerable testator. Now, the facts didn't bear that out, but as a trustee or co-trustee, you're looking at it going, hey, what do I do here? And what can I employ to try and figure this out? And combined with the facts seem to read that William was very private, that he in his relationship with his advisors would be upset if they were too stern with him or they directed him in a way that he didn't agree. And so that was obviously a very difficult client in terms of the papering.
Yeah, and look, the practical reality, not to beat a dead horse, it's really the evidence of intention used by the parties that's often derived from the drafting solicitors and the financial advisors. That's really, home base for that evidence, and it just didn't bear out here. And lawyers are often reminded of their duties and should adapt best practices, such as keeping clear and contemporaneous notes of any discussion regarding the transfers, because this is really where it can come back and cause big problems. And
So,
two,
Bryan,
I think,
Bryan,
yeah.
just on that, in terms of the takeaway too, that I think it's one of those cases that it's long because it was a lot of facts. So, this is a good judge who wrote a good decision, but had to struggle with competing set of facts that would have been tough for a judge, but you imagine for the litigators to corral in. And one of the themes that you see on these cases is, first of all, the law is straight as an arrow, right? McNamara decision and all of his supporting what the thresholds, Frame and Smith, all the threshold tests there. So the judge didn't have to go create new law. But an underlying theme that I could see through this decision was the widow wins. And I think that judge must have struggled with that. And Justice Lissman 100 years ago told me that in open court many times. The widow wins, or the spouse wins, and the surviving spouse wins. And it was really interesting how the courts, you see this theme being picked up by the courts a lot. And that is, no matter how hard you try, you're going to need to resolve sort of foundational elements of any relationship. And if you've got a widow floating out there that isn't supported properly in the mind of the judge, they're going to find a way. And I think that this judge quite properly found a way with very awkward set of facts. And as you say, Kim, if you glance over this, if you read the book by the cover, you can prejudge this pretty quickly. But as you start to read how the facts unfold, you realize that it was a relationship of a serious relationship, the girlfriend, and it was something that the judge found that, but I mean, it was something that you couldn't ignore that. So I really like the decision to teach us some themes as to how to manage our cases too, and that's one of those themes.
Yeah, that's interesting. And there's a good bit of analysis in there too about how a court is going to give, deference to the autonomy of the donor, even if those decisions are controversial. And again, easy to read the facts at first instance and jump to some, assumptions and conclusions. But, you know, the decision proves that a transferor may do what he pleases with his property. But when litigation ensues, the intention of the transfer must be clear, and that's really key. And the court must balance these transfers against the legal presumptions of bargains and gifts. And I guess just one other takeaway too. I mean, we were talking about, you know, testamentary intentions, but if we're not dealing with that, but, you know, gifts during lifetime inter vivos transfers, we also need to remember deeds of gift. It's a reminder that recommending that to a client may save a lot of expense and hassle and conflict. A deed of gift, it acts as evidence to show the intention, and it's a tool that could assist or go some way to resolving some of these issues.
It's so true, you know, and I always get grumpy as a litigator, and I get a file and you know that a deed of gift might have closed the door to the claim, or vice versa. When there's no deed of gift, I'm clapping. The other thing about this case is, you know, the volume work in this area, as we all know, is growing, and the stories are sometimes worthy of attention from third parties like the media. And this was a tough one too, right? All counsel had to struggle with the fact that there was a Toronto Life article out on this before the decision came out. And it was just a good lesson. I mean, I know all the counsel on that, and they had to be very circumspect about how they managed that, and they all did a terrific job. But we have to be aware that if we get approached by the media on these cases, especially on a case like this, where, as Kim, you said, on first blush, you could really maybe misread some of the behavior, and you see it all the time with predatory marriages, Kim, in your cases, where you've got a situation where, you know, maybe it isn't so predatory, maybe it is very difficult, but if you've got a story to tell or a fancy name involved, we as lawyers are now more and more having to manage the media, and everyone has their own techniques. I typically am not very adept at it and try to stay away from it when it comes at me. But I don't know what, Kim, yours and Bryan or Suzana's experience is with the media. That's something that, you know, there's a case that on the face of it was relatively modest in size. I mean, this wasn't a famous Toronto family in that sense. So the media grabbed on the story, not the money. I mean, it's not the name. And so I don't know what your practice is over your firm, but Kim, I know ours is, dealing with media on almost any file can occur.
Yeah, you have to be careful. Of course, I was interviewed for that Toronto Life magazine article, but I wasn't told it was in respect of this decision or this case or this, like, I had no idea. It was quite independent on concepts, and so that was surprising in the end how they use the interview contextually. So yeah. I think now Suzana's gonna talk about another takeaway.
So the takeaway that we can take from the Anatowich estate decision, I guess the reality is this decision does not necessarily change the landscape of litigation, but it does serve as a reminder to us and to drafting lawyers that we really do need to be extremely careful in accurately documenting our clients' instructions and their intentions. And it also underscores the importance of creating and keeping contemporaneous notes during the entire will-taking process. In order to avoid litigation, we're going to want to ensure that our clients' will accurately reflects their intentions in order to prevent any conflict either between or amongst beneficiaries down the road. And in those cases where a will doesn't, we also want to be aware of the fact that the court does have this equitable power to rectify a will if it's proven that the will was not drafted accurately to set out the testator's actual intentions.
So I just I'll come back to my takeaways a little bit from my first case. In the limitation period one, we had as I said, the privilege of arguing this. And one of the things that my partner Doreen, who co-counseled on this with me, was very helpful, was that we sat down before we argued this and started to put different variables into the analysis to see what damage might be done if we limited it to less than 10 years. What is going to be the impact of the 2-year limitation period? Easy to say, oh, we'd like to administer estates faster. but what damage might be done from other scenarios. And we've got an interesting scenario in the chat about that too. There are all sorts of variables here, and that's why you refer to the Gomez case, because in that case, I think in part because the Trustee Act wasn't brought to the attention of the court, the analysis may have fallen in the same way. But the idea of limiting periods of time like this, it does have a major effect on equitable claims, right? I mean, remember, this is an equitable claim, and the courts are very firm and have been very firm since Justice Greer's decision, and giving 2 years to limitation periods. Neuberger to do a will challenge, some limitation of discoverability, which I really like that point, Bryan, that you've raised in that Court of Appeal decision. They're going to give you a little bit of room. They're not going to give you 10 years, but but you can't sit on your hands either. But I think the Ingram decision really keeps us focused, and that is, from a practice standpoint, presume date of death plus 2 years. You might get lucky with discoverability, as Bryan's described. You might get lucky with somehow getting outside of into the Real Property Limitations Act, only because there may be a little tiny window that's still left with the Gomez decision. But it's not the way to practice, and it's not the way to get good sleeps at night. So that's how I came out of that case.
So staying in line with that discussion, looking at Shannon and Abrovsky, my first case, it's a reminder, clarification to lawyers that the discoverability principle found in Section 5, it applies to estate claims, right? And so it first came out in Grant Thornton in New Brunswick, the Supreme Court of Canada decision, reaffirmed in this case. Once a claim has been discovered, there's a 2-year period that the proceeding must be commenced, otherwise it'll be statute barred. And again, in this case, in the Court of Appeals opinion, it is unreasonable to start a proceeding, such as a will challenge, without knowing the will's contents and the bequest. That makes sense on a high level. You don't know what you don't know. If you don't have it in front of you, how could you ever possibly, go forward with your best foot forward on a claim? And having mere suspicion that a will may have been signed and what it might or might not say, that's not enough to trigger the start of a limitation period to start the time in which to bring your claim. But with that said, I mean, you might get it, right? As Ian was saying before, it's a bit of a difficult balancing act. I mean, I don't know what you guys think, but it's been so ingrained, at least into me, that the 2 years from date of death it's always in the back of my mind. It's always ticklered. It's always there. And I think you got to be really careful in how you go about this on a case-by-case basis.
I agree, Bryan. And I also think, we see many times where our clients are particularly turning to us and hesitant to provide copies of wills to people who are not named in the will or who have no financial interest in the estate. Technically the rules say they don't have to be provided with a copy of it, but the practicality is that the sooner they know that they're not in the chips, probably the better for all of us. And, we have to let that feeling of entitlement, perhaps in these cases, go, and just let them know that if they're going to do something, do it now. And we're going to have to deal with it, whether we do it now or we lay in the weeds. Might as well face it earlier rather than later.
Yeah, I mean, basically lets the clock tick on, doesn't it? If you do it. I mean, there's obviously lots of illustrations where you don't want to, but on balance, you're right, Suzana. Let's just get it out there. And they couldn't have got around, in your case, Bryan, they could not have got around it if they'd seen a copy of the will. Mm-hmm. I was involved in a decision called Virtue years ago. The decision was, it's not Court of Appeal, so it doesn't matter like your case does, in the sense that this clearly sets it out now. But it was the same problem, and the will was produced like 2 years and a month after date of death, and limitation period. Well, they've said discoverability, and in that case, it was probably the right answer because it was a month, and that's seriously. But you're right, like Suzana, why not just get the bell, ring it, and see where it goes? Now, that's obviously an overstating. There's some nuancing to that, but that's certainly a really good point.
Yeah, no, it's interesting. And then if we look at Barbieri and White, so this was an interesting one because I think, there were some tactics here with respect to the consent order for the complete estate accounting that I think it could be interpreted as backfiring in the circumstances. But just if you think about this decision globally, I mean, it's a reminder to us, to lawyers, that you really got to think carefully about the implications that come along with these broad stroke orders, accounting orders that go through on consent, and whether or not in the circumstances you need goalposts there to protect yourself and protect the solicitor-client privileges between you and your client. Remember that in this case is that the estate trustee was to provide a complete estate accounting. It was consented to. That's not all that unusual. But again, you can't use the concept of solicitor-client privilege as a sword and a shield to kind of finagle your way through it. I mean, in this case, the court was clear that it was expressly waived by virtue of that consent order. So I think you just really got to give that some thought and be careful.
But you're right, Bryan, in a sense, like obviously they played too cute in the court's mind on that. But Suzana, like the question of solicitor-client privilege is always one of these interesting things. Like we know it survives death, but what are your thoughts about how it's managed just generally? And that what's that old decision from the 1920s that allows what do you do when someone comes in to see you, does a will? What's the expectation of a lawyer at that point? Is the solicitor-client privilege attaching at that moment in time, or how do you deal with that once they're dead?
Yeah, I mean, I think that's an interesting debate. I mean, there certainly is an exception to the solicitor-client privilege, the wills exception, they call it. That goes back to a very old case where there is this expectation that if you're retained to prepare a will, that document is not meant to be kept in your file and never produced. It's meant to be produced and relied upon by the state trustee to administer the estate. So there's an exception to that strict rule where we can't say anything that's in our file or reveal anything in terms of our retainer.
Sorry, we're getting a little feedback, not sure why. But the other part too, Kim, you did the model order for the court with a group of us, and it's solicitor-client privilege in the orders, but the duty of confidentiality too, right? And
yes, and the duty of loyalty, I think we often include as well.
Yeah, tell me your thinking on the duty of confidentiality part in the form of the standard form orders in Ontario we use. We always say we can waive the privilege and the duty of confidentiality. Why do we need both in your view?
I think to protect the lawyer, I mean, even the rules of professional conduct say that we have to hold information disclosed by a client with confidentiality and with the duty of loyalty. And so I think we want to make sure that when we disclose our file that we're covered, that we're not doing something offside any of the rules, and that we're authorized to provide the file or documents that have been requested without reprisal.
Yeah, it's such a good point because like the common law says solicitor-client privilege survives, goes to the executor, except if the will is being challenged or their authority is being challenged, right? So the other part of it is, of course, our ethical obligation of the duty of confidentiality. So if you cover off the common law piece with a solicitor-client privilege waiver in the orders and a duty of confidentiality, nobody can say you've breached either your regulator or the common law. So I get that's a good point, Kim. I'm not sure whose next takeaway it is. I'm running out.
Next takeaway would be mine, and that is in respect of the Levesque decision. I think this case really serves as a caution to us as lawyers that we shouldn't make the mistake of relying on inherent jurisdiction of the court when we're making disclosure requests to fiduciaries that go way beyond what is typically entitled to, or what we would be entitled to pursuant to the statutory authority. So, for instance, there still has to be some proof of malfeasance or misappropriation of funds to merit something more, a more extensive disclosure request. And as officers of the court, we really do need to set out and rely upon the underlying authority for our requests, whether it be evidential or legal. And we need to set out what it is that warrants this additional disclosure in the circumstances. And if we fail to do so, then it may be that a court is going to find that our requests are, in quotes, nothing more than fishing expeditions, and potentially, drawing adverse cost consequences against counsel or the parties as a result.
So I think mine's one of another cost is the final drenning. Again, you know, I think it's just, from my perspective, the courts are going to scrutinize costs. The Toller-Cranston decision is another one where the court looks to behavior, but proportionality. The Drennan case had spicy facts on proportion, on behavior, but and non-responsiveness. So you've got sort of three categories. If you cause the problem and cause the other side to increase their costs, you're going to pay for it. If your behavior is inappropriate and ignoring court orders, you're going to pay for it. And in the Toller-Cranston case, and I'll add this to our list when it goes out, proportionality drives the quantum. And so if you're acting in a disproportionate way in the context of your size of the estate, that's going to drive a cost order one way or another. So I keep those three factors in my mind, and always watch out for costs. Gone are the days that my father got to practice where costs always came out of the estate. And, you know, it's been a hard time since then. Times have changed.
Yeah, indeed. Okay, so that leaves me with wrap up. And so just in concluding today, it seems that the cases of 2024, there was a bit of everything. Our courts were addressing, I'm going to say, quite a few appeal decisions in estates and trusts. Limitation decisions had been silent, I think, for a few years. They were numerate. A reminder that limitations must always be known, thought about, prioritized, ticklered, as Bryan indicated. These decisions should also remind us that the job of the lawyer in advising a litigant client really has to include clear warnings and risks, pros, cons concerning unexpected outcomes and potential cost consequences. Not very much said about mediation in any of the cases, although there were in some of the power of attorney cases. Obviously, it should always be considered, and I'm going to say the earlier the better. Conduct, including abuse of process. We saw fishing expeditions in quite a few cases, actually, especially the power of attorney cases of 2024. Scorched earth litigation is not only increasing as a key factor in the cost treatment and consequences, but it's also increasingly not well tolerated by our courts in the substantive outcome. This makes sense because we deal with extremely emotive proceedings where the heart and passion can lead to the absence of reason and rationale. And just one further note on costs, and I say this all the time to my colleagues, I'm always met with some opposition, but if we go back, it's still within the year, but it's a 2023 decision of Adam and Adam. It'll be put in the chat and added to our PowerPoints when we distribute it. This was the decision from Ontario. It was Justice Sanfilippo. It involved an application commenced to remove 2 attorneys for personal care and then, of course, a guardianship appointment. It was lengthy. There were complicated facts. I'm not going to go into any of them, only to say that the applicant was successful and sought full indemnity costs against the attorney that was removed, but not from the incapable person. And Justice Sanfilippo awarded the applicant a portion of the costs claimed against the attorneys who were removed and ordered full indemnity costs of the Section 3 Council. But importantly noted that the applicant didn't seek costs against the incapable person, yet Justice Sanfilippo would have been minded to award those costs on the basis that he viewed the application as entirely for the benefit of the incapable person. So the moral of the story is, in all of your court proceedings, if you have the foundational components to support an elevated cost order, then ask for it. What's the worst that can happen? A resounding no. So it's important, and you don't ask, you don't get. And so with that said, I'm not sure if there are now any questions. I think we seem to answer them along the way. So I think that subject to Suzana and Bryan, Ian, is there anything else you wanted to add?
No, nothing on our end, Kim. Thanks very much to you and Bryan.
Oh, great.
That concludes our webinar today. Over to you, Mallory.
Thank you so much, Kim. Thanks to all of our speakers today for sharing their expertise with us, and to everyone in the audience for being here with us. Keep an eye out for more upcoming webinars, and please enjoy the rest of your day. Thank you.
Thanks, everyone.